The Court of Appeal to throw out the case by petitioners, claiming the Constitution is anchored in eternity clauses that cannot be repealed through the BBI process. The respondents told the court that the petitioners have failed to demonstrate that the president was just a supporter of the initiative and not a promoter of the process. Lawyer Elias Mutuma, representing Third Way Alliance, challenged the assertions by the BBI secretariat and Raila Odinga that Denise, Waweru and Suna East MP Junet Mohammad were the initiators of the BBI.
Third Way Alliance lawyers in the BBI petition at the Court of Appeal questioned the president's involvement in the process, saying he should have recused himself from his office if he needed to initiate a popular initiative.
So if the president then wants to initiate such a process as a citizen, he must of all do exactly that. Announce to us that this is not the president doing this, it is me as a citizen.
According to respondents in the petition who support the High Court ruling, the Constitution is anchored on eternity clause that cannot be repealed through the same Constitution but outside its confines.
Involve the people directly in a manner that they are amending, or rather they are creating a new document altogether.
His sentiment supported by Professor Kithure Kindiki, who says the rushed BBI process, likened to the Simon Makonde story, had the president's footprints all over.
The launch of the collection of signatures exercise and all other events associated with this ill-fated exercise or process were presided over by the President of the Republic of Kenya using state machinery, and none of these meetings or events took place in anybody's private home.
Kindiki would further table the findings of the JLAC report that shows evidence that the proposals were unconstitutional.
It was clear from the report and from the Hansard proceedings that the finding of the report was that many provisions in the bill, the proposed amendment bill, were unconstitutional.
David Ndii and 4 others, through their lawyers Nelson Harvey and Esther Angawa, demonstrated how the bill was aimed at tampering with independence of the judiciary by introduction of the ombudsman.
It has sought to interfere with the independence of the judiciary by installing an executive prefect in the name of Obchinski, aka Ombudsman.
Verification of the signatures, public participation, as well as debate on multiple questions form the basis of the respondents' arguments.
Cannot say that provision requiring a quorum of 5 does not exist today because of a declaration of unconstitutionality made by Justice Chacha Mwita on 6th of April 2018.
But whenever we have a referendum in our nation, there should be a nationwide voter registration exercise. Secondly, that we must always have a multi-choice referendum.
It does not comply with Article 10 of the Constitution. There was no public participation.
With a day remaining to the conclusion of the hearing of the BBI appeals, the opposing respondents continue to give their submissions, and thereafter the judges will be required to retire to go through the submissions and subsequently give a judgment. For Business Insight, I'm Serafina Robbie.